Hey everyone, and welcome. Today, we're diving into a legal story that honestly sounds like a detective novel. It's called The Case of the Two Dusts, and believe me, it completely flipped how the law thinks about who's to blame.
But before we get into the details, I want you to think about this question. If you're harmed by two different things, but you can't scientifically prove which one was the real culprit, does that mean no one is responsible? Just keep that in the back of your mind as we go through this.
All right, let's set the scene. We're going back to the 1950s to a steel foundry in Scotland called Bonington Castings, and our story revolves around one of its employees, a man named Mr. Wardlaw. For years, he worked in this tough, dusty environment, operating heavy machinery day in and day out.
And after all those years on the job, Mr. Wardlaw got some devastating news. He was diagnosed with pneumoconiosis. Now, this isn't just some cough. It's a severe, irreversible lung disease that you get from breathing in tiny dust particles over a very long time. For him and his family, the stakes were unimaginably high. So, Mr. Wardlaw decided to sue his employer. He argued that the conditions at the foundry were responsible for his illness. But this is where things get really complicated, because it turned out the dust wasn't just coming from one source. So, check this out. There were two types of dust in the air. First, you had what we'll call the guilty dust. This came from swing grinders, and the company was legally supposed to have dust extractors for them, but they didn't. That's a clear failure on their part, a breach of duty. But then, there was also the innocent dust. This came from pneumatic hammers, and back then, there weren't any safety rules for them. So, legally speaking, the company wasn't at fault for that dust. And here is the absolute heart of the problem. Mr. Wardlaw had been breathing in both kinds of dust, all day, every day, for years. And the doctors, the scientists, nobody could say for sure if his disease was caused by the guilty dust, the innocent dust, or the combination of the two. It was medically impossible to tell them apart. This scientific uncertainty created a huge legal roadblock for Mr. Wardlaw. He ran smack into an old, rigid legal principle, a real dead end called causation. You see, the traditional rule the courts used is something called the but-for test. It's a pretty straightforward idea. You, the claimant, have to prove that but for the other person's negligence, you wouldn't have been harmed. It's like a line of dominoes. You have to prove their action was the one that tipped the first domino. And you can probably see how this whole thing just falls apart for Mr. Wardlaw. To win, he had to prove that but for that guilty dust from the grinders, he'd be perfectly healthy. But he couldn't. How could he? Since the innocent dust was also there, it was impossible to say the guilty dust was the one and only cause. The but-for test failed, and it looked like justice was completely out of reach. But then, the case made its way to the highest court in the land. And the judges, seeing this impossible situation, decided to do something pretty radical. They realized that when an old rule leads to an obvious injustice, maybe you need a new way of thinking. And in their final judgment, they said something that would echo through courtrooms for decades. They said, you don't have to prove the employer's mistake was the only cause of the harm. Instead, it's enough to show that their mistake, the guilty dust, made a material contribution to the disease. And just like that, the material contribution test was born. It's a whole new standard. It says that if what the defendant did wrong contributed to the harm in a way that's more than just trivial, more than minimal, then they can be held responsible, even if other things were also part of the problem. I mean, how brilliant is that? The court totally shifted the perspective. They stopped asking the impossible question, was this the only cause? And instead, they started asking a much more practical one. Did it materially contribute? And the answer to that question was a definite yes. And with that simple, elegant change, Mr. Wardlaw won his case. Now, this was obviously a huge victory for one man and his family, but the story doesn't end there, not by a long shot. This decision, made almost 70 years ago, created a powerful legal idea that is arguably more important today than it has ever been. Its legacy is just massive. For starters, it gives people a path to justice when the science is super complex, or even impossible. Think about modern lawsuits over things like environmental pollution from multiple factories, or really complex medical negligence cases. It puts fairness above rigid, old-fashioned rules. And maybe most importantly, it means that a wrongdoer can't just wiggle out of responsibility by pointing a finger and saying, hey, maybe it was that other thing over there. And that really leaves us with something to chew on. In our world, so many of our biggest problems have multiple tangled causes. Everything from climate change to the influence of giant tech platforms. So how could this powerful idea of material contribution help us figure out who's responsible and what justice looks like today? It's a huge question. Thanks for digging into this one with me.